Thank you. Director Jorna Hansky, many thanks for your kind introduction and work. Director General Francis Garry, you make with your introduction my life very easy, because many of my comments certainly relate to what had been said, and the same to the previous speaker, Tenu Ross, that not only made an impressive, very clear introduction to the main concepts about artificial intelligence, but also conclude in a very clear manner about the impact of artificial intelligence on IP rights. I will probably elaborate further in some of those issues during the presentation, and I will be able to start taking Director General Garry's points on artificial intelligence in the following way. Artificial intelligence has not only impact on on intellectual property law and policy for sure, but also on the way the administration of the IP system is going to be impacted via artificial intelligence. And this will be probably the structure of my presentation. Two elements is impact of artificial intelligence on IP law and policy, and then impact of the IP policy and law on artificial intelligence. And you will see that there are challenges in both approach. If you take few prominent examples of artificial intelligence, it is clear that the impact of artificial intelligence is taking place not only recently, but also from quite time from now in areas very diverse in which we are already exposed. Is the case of autonomous vehicles like the self-driving cars and drones, is the case of online assistants like Siri, but it's also the case of robots in the area, for example, of medical robots, where a number of artificial intelligence is already available, and the practice of many medical doctors worldwide benefit from the existence of those robots. What probably is changing a little bit is the availability of more sophisticated development, like is the case of Sophia, that you have been exposed to the press in recent times, and particularly the element of innovation that involved that robot to make the robot a lot more human compatible, and probably to look like humans, and not only to perform and to perform certain tasks that demand intelligence, but to look like. And this is, of course, something that makes artificial intelligence more challenging, not only from the IP point of view, but also from many ethical considerations that are going to be mentioned later on. So the point is how IP can benefit first the work of intellectual property offices worldwide. And I took three examples from WIPO. The first one is this machine translation, this WIPO Translate, that is producing a huge impact in the way patent applications are translated. And here, the fact that this artificial intelligence is able to learn from each one of the previous experience and to do a better job next time in the translation, make it certainly a very interesting tool for intellectual property offices worldwide and for WIPO in particular. The same example that was already mentioned by the Director General related to image search in the case of trademark, where it is increasingly very difficult to conduct manual search, and without any doubt, the help of artificial intelligence in that area is helping IP office in the analysis of trademark applications. And then other tools like, for example, automatic patent classification. You know how difficult and how complex is more and more the issue of classifying inventions for the purpose of patent applications, and how even not only the international patent classification that we manage in WIPO, but certain office has implemented other classification mechanisms what made the life of applicants quite complex. These few examples of how artificial intelligence, without any doubt, is impacting IP offices worldwide. One of the important challenges here is that the efforts conducted in order to develop those tools or take place in a coordinated manner. Otherwise, probably those efforts are going to be wasted in different regions of the world. And in that sense, coordination at the multilateral level will make that the uses, the resources used for those purposes are appropriate. But when it comes to the second question, that is not only how artificial intelligence can be a benefit for IP offices, but to the second question, that is how the patent system may impact advances of artificial intelligence. And here, there are many considerations, and there are many elements, but there is one that, in my view, is critical, is the definition of patentability. If we know the development that artificial intelligence is taking place today, is most probably because in the main areas, in the main critical technological areas involved in artificial intelligence, patents are available. And because of that, patents, without any doubt, boast the innovation taking place in that area. So we will develop certain elements later on in the presentation, but one critical aspect is patentability. And as you know, there are certain challenges on patentability of, for example, mathematical methods, algorithms, and software in certain jurisdiction. And the way patent offices address patentability in those areas will have, without any doubt, a direct impact on artificial intelligence, and particularly in how patents encourage and promote artificial intelligence. But let's analyze the other way around, how the developments in artificial intelligence is challenging the patent system. And in that sense, few questions may be mentioned here. The first one related to the claim construction in the area of patents. Then we can mention issues related to inventorship and ownership. We can go even not only into the issue of requirement of patentability, but also related to areas like enforcement. Let's mention a few of those issues. In the area for example, patents and inventorship, it had been already stated by my predecessor that there is no way to consider that artificial intelligence can own IP rights. And that, in my view, may be true. But the real question is whether artificial intelligence can be considered an inventor, whether a machine that invents, in the technical sense, can be an inventor. And in that area, there are different views, of course, as always in legal issues. But the main view expressed is that the concept of inventor in patent law is attributed to a natural person. And if we take multilateral treaties like Article 4 of the Paris Convention, the reference is made to an inventor in the sense of a natural person. So in the case of artificial intelligence machines that are able to develop inventions, the question is as follows. If we consider that those machines are inventors, we have a problem in the patent law, not only because the main patent law regimes worldwide request that the inventor be a natural person, but because of the main and the basic principle of the patent system that is to encourage and promote innovation. And in this case, those machines are acting without the need of any incentive. If we take it the other way around and we say, look, we need always to have an inventor as a natural person, then we can consider that those that are behind the development or the design of the machine are the true inventors. For example, it could be the manufacturer, it could be the operator, it could be the owner of the machine, it could be the user, or finally, it could be the software development. In all those cases, those behind the technological development still to be considered on the current patent law regime the inventor. And if that inventor is a natural person, then the general principles of patent law will keep playing the role of the promotion of innovation. Then the question is, can, if it is not an inventor, be considered that machine an owner? That's a different question. The answer was given by my predecessor in the previous presentation. The answer may be no. But here I can see probably the hope for a more clear evolution, because if we have in the traditional legal concept the idea of the difference in between natural person and corporations as a fiction entities, then fiction entities can exist in other areas, like in robotics. And if one corporation can own IP, why not one entity that receives this personhood status can at a certain point become owner of IP? So I can see, from the legal point of view, probably more evolution in the area of ownership rather than in the area of inventorship. But who knows? Those are very recent questions, and we need to see how discussions continue. And probably what is more relevant today is making those questions and making the right question rather than try to give answer, because we need to wait and see the evolution on that area. In the area of patentability and the area of exclusion is probably where the more challenges exist. As you know, in the area of algorithms, computed software, and in the area of mathematical methods, there are rules that are quite diverse in different jurisdictions. And the tendency is to open patentability in that area, and the very key and particular interest of those areas in artificial intelligence probably will push the boundaries in order to open patentability in a clear way in jurisdictions where they are not available. But we know the evolution taking place in different jurisdictions. I will not get into the details, but discussion, for example, in the European Patent Office has even moved into the direction of adopting guidelines on the analysis of patentability of artificial intelligence, and particularly the application of rules on computer-implemented invention when it comes to the analysis of artificial intelligence application. And probably this will be the practice adopted in other jurisdictions. Now, there are doubts in very specific areas. If you have a robot in a case of medical, for example, surgery, it is, from the robotic point of view, probably an area where patents are available. But then you need to deal with other exclusions of patentability, like, for example, surgical methods or diagnostic or therapeutic methods that may also apply in very specific areas where this artificial intelligence is taking place. So again, here the idea is to highlight how exclusion from patentability play a role in the area of progress of artificial intelligence. Of course, if patents are available, more innovation will be coming in those areas. In the area of enforcement, we don't have cases so far dealing with actions that involve, I would say, a willful intent of infringement from artificial intelligence machine, for example. But if that happened, then probably available rules like those coming from the European Parliament may be quite clear. For example, they attribute to robots not any responsibility, but mainly for those that are behind in the manufacture or the operation or the owner or the user of those machines are those that are going to be accountable for any infringement taking place for those, let's say, artificial intelligence machines. But in my view, the current rules of IP enforcement apply, and because of that, those will be enough to identify who is going to be accountable in the case of infringement. Probably one graphic coming from the recent report published Use Life Friday by WIPO shows the very important role of patents in the area of artificial intelligence. And it shows particularly a very important point here in which patents goes up in the total number of patent applications, more than 160,000 patent families worldwide in the area of artificial intelligence. And it shows how publication of papers went up quite some time before, but the ratio in between papers, scientific papers and patent application is going down because of the increase in the total number of patent applications. So certainly, as the Director General Gary Hughes mentioned before, patents applications in the area of artificial intelligence is, without any doubt, an area of very fast growing rate. In which areas? Well, the main one is this machine learning area, and probably this is the area with the more number of patent applications taking place, more than 134,000 family patent applications being filed. And the way these machine learning applications are distributed are among these different ones here. For example, neural networks being the first one with more than 42,000 families patent applications worldwide. And if we go to the different functional application of this artificial intelligence, then you will see the way this artificial intelligence is applied to the different areas and technology field. And here the first one is computer vision, followed by neural language processing and speech processing, and then it goes down to a less reduced number of patent applications. But if we take the example of robotics that have been a technology area with a number of applications worldwide for a number of years, you will see that still quite focused and quite concentrate where this technology is coming from. In dark blue, the countries and jurisdictions where more patent applications are coming from. So certainly there is a gap in between those that produce the technology and others that will be more recipients of that technology. If it comes to the who is doing innovation in that area and who is using patents, this statistic comes a little bit before of the release of the WIPO report, but it just confirmed by the WIPO report that the first two actors are IBM and Microsoft in the total number of patents. And you will see within this distribution the number of patent applications that relate directly with artificial intelligence. And finally, the number of patent applications by make actors in the area of artificial intelligence, but particularly in companies that you are very familiar with, like Microsoft, Facebook, Apple, and Google. But, and this is probably more relevant, the number of applications coming from startup companies, and for those in particular, when they have been interviewed about the role of patents in the development of those companies, all of them coincide in that, in the fact that patents plays a very important role in the progress of those companies, and particularly in promoting the possibility of making business and getting investors from abroad, and facilitating the possibility of the success of those startups. So without any doubts, patents play a very important role in promoting innovation. The challenges that the patent system face in very specific areas are not, for now, they will be probably questioned for quite a while before conclusions are taken, but without any doubt, this is a very key area for policymaking discussions at the international level, and I'm sure it will be also part of the discussions related to international norm-setting work in organizations like WIPO. Thank you, Director General.
Thank you so much, Marco. If you could please stay there for a second, we'll take a question for you. And I think I know my audience. I think I know my, especially people from our office. Now there's a time for one question. Who will pick as a volunteer now making a question? So please raise your hand if there's something. We still have 5 minutes to go before the coffee break. Now is the time to earn the coffee. So please raise your hand, and people. And who are the people with the microphones? Where are you? Here is one, and here's another. So, who will volunteer to make a tricky question to Marco?
There is one.
Okay, there is one. Please state your name and organization that you represent.
Christian Luoto, Seppolainen. I have a question regarding the inventorship idea of artificial intelligence. It has to do with expiration. As we know, software gets updated and diversified over time, so the original algorithm will not be the same as the original one was, albeit it still have the same creator, of course. Another expiration-related issue is the human life. If an algorithm generates an invention after the creator has died, who is the inventor then? Yeah. Thank you.
Mm-hmm. That's exactly the point on the inventorship consideration. As you rightly pointed out, there are two elements there. The first one, what happened when the initial algorithms evolve? Well, it happened in other IP examples. In the area of innovation, for example, many of the initial developments also progress and also develop, and the question is whether the new developments constitute a new invention or not, a separate one. It may be that what you mentioned in the case of algorithm development is whether the new algorithms also deserve an independent protection, in which case we apply the traditional concept of patentability. It may happen, and in the case of artificial intelligence, that what is changing is not the algorithm but the data that is processed. It may be the same algorithm, but with more and more data. That is what made the machine more intelligent every time. And in that case, of course, there is not a change in the nature of the invention. What is a change is in the management on the data, in which case the patent system is not touched. Then all the data considerations needs to be made, or all the consideration needs to be made on the data. That's the first part of the question. The second part, if the machine itself is able to invent, and we have, this is not science fiction, we have few examples already taking place in certain applications in a number of jurisdictions, where a given artificial intelligence machine have come up with a technical solution that is patentable, and that has been the subject of patent applications. Now, if the law requests that only natural persons be considered inventors, then it will be the software designer or the developer, the one that will be named as inventor in the patent application, although the invention is coming from the machine. At least in all those jurisdictions with only natural persons are inventor. What is the majority or the practice worldwide today? So that's the option. But it is a reality that those machines are able to invent, and the applicability of those machines in looking for technical solution have proved to be a very valuable one. So yes, patent law today answer will be, it will be the designer or the programmer, the one that is going to be named as inventor in the patent application.